Thanks to Int'l for hosting this, this event. This event is the second in a series of events in Women in the Law, looking at international law and the Dobbs decision. And so I encourage everyone to check out the other, the recording of the first one, and the second, or excuse me, and the third one is to come soon. And what we're looking at here is international law and the Dobbs decision. Of course, we know the US Supreme Court in the decision of Dobbs versus Jackson Women's Health Organization struck down the right to abortion in the US. And the decision puts the US in rare company among only a few countries in the world where women's rights and reproductive rights are regressing. The Dobbs decision failed to address international human rights norms and, in fact, departed from global trends. So today we're joined by four incredible experts here to put the Dobbs decision in a global perspective with consideration of human rights regionally, globally, outside the US, and to consider the implications of Dobbs for human rights around the world. So I'm going to introduce our panelists, and then I have questions I'll ask each one. I'm hoping that we'll have a little bit of time for questions at the end as well. We're first going to hear from Melissa Upreti, who's a member of the UN Working Group on Discrimination Against Women and Girls. Melissa is a human rights lawyer, one of the human rights advocates and women's rights advocates I admire most, and has spent nearly 2 decades advancing women's rights through a variety of means, through national, regional, international law mechanisms. Her work is extensive. Melissa's led fact-finding missions, strategic litigation, capacity building for civil society, and has provided technical support for governments reforming laws in Asia. Melissa was the founding attorney of the Asia program at the Center for Reproductive Rights, where we met, I counted 20 years ago when I was an intern, and has written and lectured extensively about women's reproductive rights and the importance of legal accountability. We're so grateful, Melissa, that you're here with us today. After Melissa, we'll hear from Sylvia Serrano, a human rights expert and now the Associate Director of the Health and Human Rights Initiative at Georgetown University. Sylvia is a human rights teacher and trainer for state officials, human rights defenders, law students, and civil society organizations. She came to Georgetown from the Inter-American Commission on Human Rights, where she was an attorney in the executive secretariat and acted as legal counsel for the Inter-American Commission on cases of international human rights on a range of issues, some of which included gender-based violence and reproductive rights. And so we're so grateful, Sylvia, for you for your joining us today with your breadth of expertise in the Latin America region. And then next we have Professor Charles Nguena, who's a professor of law at the Center for Human Rights at the University of Pretoria and at the Gruber Program for Global Justice and Women's Rights at Yale Law School. Charles publishes at the intersection between human rights and health, including reproductive rights and sexual health, and someone whom I consider to be the preeminent expert on human rights in the Africa region. Charles also publishes in the field of disability rights and race and culture, and serves on editorial committees and editorial boards, and as editor at what I would say a surprisingly large span of international journals and books about African law, disability, human rights, and sexual and reproductive rights. I also happen to know that Charles is incredibly warm and generous with his vast knowledge and guidance, and so I really thank you for joining us. And lastly, we have Lucia Vera-Pizarroza, an associate and postdoctoral fellow at the O'Neill Institute for National Global Health Law at Georgetown Law. She is an international human rights lawyer working on sexual and reproductive health and rights and focusing on the intersection of law, health, and gender. Lucia is an award-winning, a prize-winning researcher, incredibly prolific, and her work on sexual and reproductive rights has been published widely in health, and law publications. And I consider Lucia to be the global expert on self-managed abortion and the law, and also one of my favorite collaborators. And it's always really nice to be with you. We've had a lot of opportunities this fall, and I love it. So I want to start with Melissa, and to kick us off, the UN Working Group on Discrimination Against Women and Girls, of which you're a member, has condemned the Texas abortion ban, which could stand under the Dobbs decision, as structural sex and gender-based discrimination at its worst. So I wonder if you could talk broadly about how abortion bans amount to sex and gender-based discrimination under international human rights law.
Sure. Thank you very much, Patty. And thank you for that warm welcome. It's a pleasure to be here today with you and with all the other panelists, many of whom I know personally. So it's a very big question to answer in just 5 minutes. So I think what I will try to do is just highlight a few key provisions of international law on which the working group, which is, for those of you who are not aware, is a special procedure of the Human Rights Council. Our role is to work with the Human Rights Council and support the Human Rights Council to ensure the promotion and protection of human rights. And the focus of our mandate is on discrimination against women and girls. So I'll just highlight a few provisions that we rely on in our work when we talk about abortion and why bans and restrictions amount to discrimination. Now, as a mandate, we do rely heavily on CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, and that framework, but we're not confined to it. So when we talk about abortion bans, under international law, specifically under Article 26 of the International Covenant on Civil and Political Rights, all persons are equal before the law and entitled without any discrimination to equal protection of the law. Now, in this respect, the law is required to prohibit any discrimination and guarantee to all persons equal and effective protection against discrimination on any ground, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. So based on this, laws restricting abortion access discriminate against women and girls on the basis of sex and engage states' obligations under this covenant. So for instance, this was applied by the Human Rights Committee when it found that Irish laws criminalizing abortion can subject a woman to a gender-based stereotype of the reproductive role of women, primarily as mothers, in violation of the right to equal protection of the law. So this is one example of how this definition has been applied. Similarly, under CEDAW, also known as the Women's Convention, discrimination against women means any distinction, exclusion, or restriction made on the basis of sex, which has the effect or purpose of impairing or nullifying the recognition, enjoyment, or exercise by women, irrespective of their marital status, on a basis of equality of men and women, of human rights and fundamental freedoms in the political, economic, social, cultural, civil, or any other field. Now, there is enough evidence to show that abortion bans and restrictions do indeed constitute discrimination in accordance with this definition. CEDAW requires the safeguarding of women's reproductive rights and health, including abortion access. And more specifically, it requires states to take all appropriate measures to eliminate discrimination against women in the field of healthcare. So a provision or a ban like the Texas ban obviously runs afoul of these types of requirements. An example of the application of this provision is, for example, in 2018, the CEDAW Committee concluded that abortion restrictions in Northern Ireland constituted discrimination because they affect only women, preventing them from exercising reproductive choice. Now, when we talk about women, we also have to look at adolescent girls who are particularly vulnerable to discrimination through restrictive abortion access. Lack of access to reproductive services contributes to adolescent girls being the group most at pregnancy and childbirth. As such, the Children's Rights Committee is another body under international law, which has actually urged states to decriminalize abortion to ensure that girls have access to safe abortion and post-abortion services. It has also called on states to review legislation with a view to guaranteeing the best interests of pregnant adolescents and to ensure that their views are always heard and respected in abortion-related decisions. They've also called for the removal of third-party consent or authorization requirements. So restrictions, again, that really sort of do not meet these standards and requirements are inherently discriminatory. Now, under international law, states are also required to take positive measures to eliminate discrimination. So they're not just required to refrain from doing certain things that might be discriminatory, but also to take positive steps. And this is also based on the notion of achieving substantive equality and addressing inequalities faced by women and girls that a formal gender neutral or gender blind approach to equality does not address. And a formal approach to equality is not sufficient to dismantle the discriminatory, racist, and xenophobic institutional structures and laws that surround healthcare and abortion services in many contexts. So in fact, when pursued alone, formal equality actually disadvantages individuals who face intersectional discrimination on multiple grounds. And there's a lot of work that's been done around this, and different mechanisms and treaty monitoring bodies have elaborated the types of issues and the obligations that arise to address intersectional discrimination. With regards to the working group, I would like to note that in the case of the United States, which we have recognized as a leader, I mean, many recognize as a leader in terms of formulating international human rights standards, the state has allowed its women to lag behind in the respect for these standards. The working group conducted a visit to the United States several years ago, in which we observed that while all women in the United States are victims of these missing rights, women who are poor, Native American, African American, Hispanic, and Asian women, women who are members of ethnic minorities, migrant women, lesbian, bisexual, transgender, or intersex persons, women with disabilities, and older women are in a situation of heightened vulnerability because of different forms of structural discrimination, and which manifests very strongly in their lack of access to healthcare, but is exacerbated by other forms of discrimination as well. Now, the persistence of racial disparities, which we do see in the United States, among other countries, in the field of sexual and reproductive health, is particularly with regard to the high maternal and infant mortality rates in certain communities. And this has also been noted by the Committee on the Elimination of All Forms of Racial Discrimination. So there's no doubt that
sorry, Melissa,
in
we'll
countries where induced termination of pregnancy is restricted by law. Sure. So these, I guess, what I wanted to do is by providing these examples is to show that there are many forms of discrimination that do intersect. It's not just one, and these all need to be their states need to refrain from discriminating as well as introduce affirmative measures. So I will answer any questions that arise later on. Thank you, Patty.
Thank you so much. And these are such unfair questions, because this is a question that would merit a whole day's discussion. In fact, you've been so amazingly concise. I'm going to similarly challenge Sylvia with another broad question. And that is really looking at your work at the Inter-American Commission on Human Rights, which is a body charged with promoting and protecting human rights under the Inter-American Convention. So I'd like for you, Sylvia, to give us an overview to describe some of the ways in which the Commission has recognized abortion rights under the Convention.
Thank you, Patty, and thank you for this invitation. Yes, I will try to provide a brief overview of the evolution and the state of things of the on how the Inter-American Commission on Human Rights, in particular, have been addressing abortion issues. And I will start, and I will try to do this in 4 points that I will try to address in 1 minute each. But I wanted to start with the first step that the Inter-American Commission gave with this regard, that was at the beginning of the 1980s, with the baby boy case against the United States, in which the Inter-American Commission on Human Rights, after pursuing a deep interpretation of the preparatory works of both the American Declaration and the American Convention on Human Rights, and reached the conclusion that allowing abortion is not incompatible with the American Declaration and the American Convention. That was the first step, saying that if a state allows abortion, it doesn't mean that it is violating the American Declaration or it is violating the American Convention. And this is important because one of the excuses, as we know, that the United States historically has been using to avoid ratification of the American Convention is actually Roe and the protections of Roe, so which is a paradox, and it's ironic at this point. So that was the first step. Allowing abortion is not incompatible with the American Declaration or the American Convention. The second step was in 2012 with the case Artavia Murillo versus Costa Rica. That was a case decided first by the Inter-American Commission and then by the Inter-American Court, in which both bodies of the Inter-American system reached the conclusion that the protection of life since the moment of conception, in general, since the moment of conception under Article 4 of the American Convention, had to be interpreted in a way in which such protection of life since the moment of conception is not absolute. It could admit some exceptions, and also that it is incremental. So it depends on the progression of the gestational age. So that was the second big step in terms of abortion, or not. This was a case about the prohibition of IVF, but it led both bodies of the Inter-American system to provide an interpretation of what it actually means, the protection of life since the moment of conception under the American Convention, to open the door to the interpretation that is going to take place very soon in another case against El Salvador that deals directly with abortion. The third step was that at least in some specific circumstances, like risk to the life or to the health of the pregnant person, or when there is a lack of viability of the fetus outside the uterus, at least in those specific circumstances, the lack of access to an abortion due to criminalization or due to factual barriers, both means international responsibility of states that are party of the American Convention. And that understanding that the lack of access, at least in some specific circumstances, implies the international responsibility of states, was framed under a number of rights. The right to life, the right to be free from cruel, inhumane, and degrading treatment, the right to equality and non-discrimination, understanding equality in the same sense that Melissa was mentioning before, the right to privacy, the right to autonomy, and the right to health. So those are the list of rights that the Inter-American Commission, and hopefully very soon the Inter-American Court, will end up using to frame the international responsibility of states when, due to criminalization or due to factual barriers, women cannot access to an abortion in some specific circumstances. And it is worth to mention that these rights are both enshrined in the American Convention and in the American Declaration. And if I have some time, I can mention something about the status of the United States with respect to the Inter-American system. And then there is the fourth line of arguments related to abortion that deal more with cases of criminalization, cases in which women, the problem is not the lack of access, but the problem is the criminalization of obstetric violence, of obstetric emergencies, I'm sorry. And in those cases, there have been some standards related to healthcare in the context of an obstetric emergency, and also confidentiality and secrecy. Some of the bans that we have seen in the United States after Dobbs create a big tension with these standards on secrecy and confidentiality. Okay, and these are the fourth lines of arguments that have been developed in the Inter-American system with respect to abortion. Very briefly, as you know, the status of the United States in the Inter-American system, the United States is not a party of the American Convention or other specific treaties, but the Inter-American Commission on Human Rights monitors and actually adjudicates individual cases regarding the United States under the American Declaration on the Rights and Duties of the Man, which includes and enshrines the same rights that have been used by both the Commission and the Court to frame the issues of abortion. And this is just for a called for advocacy and litigation efforts before the Inter-American system with respect to these tensions that I have mentioned before, because although the United States maintains the official position that the American Declaration doesn't imply legal obligations to the United States or formal legal obligations to the United States, the reality is that in other issues like migration, death penalty, police brutality, and race, the advocacy and litigation before the Inter-American system has had an impact in the United States. So this is the moment now to start doing the same with reproductive rights.
Wonderful. Thank you for that, Sylvia. And the ending will tee us up nicely for our discussion about implications for the US. I want to turn to Charles now. The protocol on the African Convention on Human and People's Rights on the Rights of Women is the only international treaty that explicitly mentions abortion and addresses abortion in the language of the treaty. I'd like you to invite you to explain human rights norms under the African Convention.
Well, thank you very much, Patty. The honor and privilege are mine to be participating in this important forum, and warmest greetings to my fellow panelists. Now, I'll make, I think, about 5 or more points. The first point to make is really to repeat what Patty has just said, in that the African human rights system has pioneered the notion of abortion as a human right in a human rights treaty. And this occurred in 2003, thanks to the efforts of African women feminists who managed to persuade the African Commission, which is a treaty monitoring body under the African Charter, that in light of the legacy of colonially spawned abortion laws, which have historically shaped a crime and punishment model that is implicated in the heavy toll of unsafe abortion in the African region, it was important to transcend the crime and punishment model and adopt a reproductive health rights model. That's really what you see in Article 14 of the Maputo Protocol. It is a protocol that doesn't really introduce new ideas about abortion, but what it does is to consolidate international best practices on abortion and conceives access to safe abortion as a health service that women are entitled to as a matter of right. Article 14 permits abortion on the grounds of risk to the health or life of the pregnant woman, risk to the life of the fetus, incest, and rape. What is interesting is that many of these grounds are already recognized by abortion laws, and it is significant that reservations by countries that have ratified the Maputo Protocol are unlikely in practice to have an effect, because they already, in many ways, concede the same grounds of abortion in their own domestic laws. What is significant about Article 14, though, is to impose this obligation on the state and to invigorate civil society in reminding domestic states of the obligation that they have to implement Article 14. In terms of the normative vision of Article 14, it is really to think about provision of abortion in terms of the norms that have been developed by United Nations treaty monitoring bodies, in particular, norms developed by the Human Rights Committee in general comment number 14, which is to think of abortion in terms of availability, in terms of accessibility, in terms of non-discrimination, economic accessibility, and information accessibility, to think of access to safe abortion in terms of acceptable services in a cultural sense and standards of good quality. In essence, that's what Article 14 does. It doesn't really invent what we don't already know, but what it does is to consolidate those standards that were developed under the International Conference on Population and Development, the Beijing Platform of Action, the World Health Organization, and equally significant, the standards developed by United Nations treaty monitoring bodies to conceive abortion as a gendered health service that women are entitled to. You may ask, of course, how do states implement Article 14? What guidance do they have at their disposal? In 2014, the African Commission on Human and People's Rights, which is the treaty monitoring body under the African Charter, developed a general comment number 2, which interprets how states can understand Article 14. It provides them with guidance. And significantly, that guidance does not contradict, but rather confirms the work of the CEDAW Committee, the work of the Human Rights Committee. So what we have in Article 14 is really a consolidation of international best standards of conceiving abortion in terms of a gendered equality to a health service that only women need. So in summary, I would summarize, or rather I would conclude by saying that Article 14 is really an instrument for gender equality, even if it falls short of recognizing abortion on request. By the fact that it recognizes health in the manner in which it has been conceived by the World Health Organization, in the sense of not merely an absence of infirmity or disease, but alluding to physical, mental, and psychological well-being, I would submit that the Maputo Protocol is really an instrument of international best standards, and it is something that I would also commend to other regions. So thank you very much for this opportunity.
Thank you very much for that overview. And I regret that we don't have more time for a comparative discussion of these different standards. Now I'm going to turn it over to Lucia, and your work spans not only international human rights law, but also helping community groups figure out how to get people the abortions they need on multiple continents. So, so given your background, I wonder if you could reflect a bit on the impact or the effect of international and regional human rights standards on abortion access for individuals.
Thank you so much, Patty. And it's like a pleasure for me to be, I am joining a group of experts from whom I learn every day, and I draw inspiration from my work. So it's an honor to be here. So as you rightly say, like I work particularly on self-managed abortion. This is those abortions that happen outside of the formal institutionalized systems of healthcare and outside of the supervision of a medical professional as a medical professional, as a registered medical professional, right? And those abortions have both draw a lot of inspiration, and they build their basis on very robust normative framework provided by the treaty monitoring bodies, provided by the international standards, and at the same time, in this like beautiful conversation between the grassroots and the norm-making bodies, they also have inspired the development of new standards and like broaden the scope and broaden the standards that these bodies are now issuing, right? So, and I want to focus on a couple of rights that were not mentioned by my colleagues here, because they are the core of self-managed abortion, right? And one of them is connected to the right to health and connected to the right to sexual and reproductive health, the right to access essential medicines, right? Misoprostol, as we know now, is a drug that was originally created to treat stomach ulcers, and by the pioneering work of women of color, sex workers in Brazil, now it's one of the innovations that have transformed the safety of abortion. So access to essential medicines, as we define it in international human rights law, becomes a key human rights that underpins the work of those who work on self-managed abortion. And the right to access to essential medicines has been recognized by various of the treaty monitoring bodies. It has misoprostol and mifepristone has been incorporated to the essential medicines list since 2015, and since then, they were first in this, what they call complementary drugs, and then in 2020, they were moved to core medicines on that essential medicines list. And the WHO also removed the need for close medical supervision. So these medicines, meaning mifepristone and misoprostol, are like an essential component on safer abortion trajectories nowadays, right? And this is very tied to the right to benefit from scientific progress. And I refer to this particularly general comment number 25, but also a lot of elaboration that has been done by other general comments in state observations, that basically what it demands is that the right to science should have a gender lens, or should have a gendered approach, particularly when we are facing a crisis, as Melissa mentioned, as Sylvia and Charles also mentioned, that unsafe abortion is a very preventable pandemic, right? And we have been using this language for a long time. And if we have misoprostol and mifepristone, we can radically change the safety of abortion trajectories, and we should embrace it as much as possible. And so this innovation is recognized, and there are very robust norms and interpretations that are already available there for us to continue building to improve access to these essential medicines lists, to these essential medicines, right? And the general comment number 22 also makes a very important point and considers that access to essential medicines, as recognized in this list, should be a core obligation to states, right? And that, I think that is like a very important standard that we must keep in mind also when coupled with the obligation to remove all laws that hinder access to SRHR, right? So meaning also that there's an obligation there when you combine the interpretation of those two norms, an obligation to eradicate also unnecessary regulatory measures, right? That at this time hindering access to the medicines. And I'm thinking here also at the example of the US, which has the REMS, that has like for a long time advocated for more liberal access to these medicines, and at the moment the FDA has adopted quite a conservative approach compared to the available evidence that research institutions continue to contribute to their work. So the other element is that abortion rights activists and abortion providers are considered nowadays, and I want to refer here particularly to the work of the UN committee that Melissa chairs. They are considered as women's human rights defenders and as human rights defenders, and as such, worthy of the protection of the state. The work that they're doing has been considered like essential to enable people to access information for abortion, for example, or support in order to access an abortion, right? And they have been slowly being recognized as human rights defenders, and particularly the UN Special Rapporteur on the Right to Health has been called into question all of those laws that have to do with aiding and abetting an abortion, that in turn end up criminalizing, right? People that support and provide information to those who need abortions. And there have been fantastic interventions of a series of the international human rights bodies and committees on cases like our colleague Justina in Poland, but also another activist in Venezuela last year, in which these committees express like a concern to these governments, right, that the criminal law has been misused to prosecute defenders for their human rights work, and that criminalization of defenders seems to appear as a systematic pattern in a way, right? So there's also that important component that allows us to protect and to start thinking of self-managed abortion as a type of abortion, as a space of abortion, as a movement of abortion that has very strong and robust normative basis also at the international level. I don't know how I am with time.
Yeah, I'm here to stop you, unfortunately, and with great regret. So I hate this role, but I have it to stop you all. But I wanted to give some time, and we have about 20 minutes left, and hopefully we'll have time for questions. But I would encourage attendees, you can type them into the Q&A box, and we can also consider them. But I did want to bring it back to the U.S. Supreme Court decision, which struck down the right to abortion. What are the implications of this for the work that you do, for the bodies that you are interested in? What are the implications of the Dobbs decision? Or why has the U.S. had such a strong rejection of international and regional human rights standards? I think I'll just ask for your quick thoughts, and we'll just go in reverse order. We'll start with you, Lucia. What do you think?
I think the question of why the US has not embraced international human rights law, it's a very complex one. But what I would like to put here on the table for all of us to consider is that the US, I mean, there are learnings from across regions that apply to the US and that can speak US language, if you may, right? I think there's a lot of conversations about, for example, connecting movements, which have been extremely important in the Latin American context. And I know that there's also very important experience in the African continent, which is connecting the movements, meaning that the issue of abortion is connected with broader conversations about democracy, with broader conversations about access to universal health care, with broader conversations about spaces for a politically active and organized civil society, right? So all of these learnings that we have had throughout the years, and I am from Uruguay, we didn't have a liberal abortion law until 2012, right? So there's a lot of us, including the people in this meeting, that we have lived for decades, and our societies have lived for decades under regimes that are very similar to the ones that the US is experiencing now. So I think it's really important that we open those conversations. Maybe there are some arguments that don't resonate, that do not apply, but certainly there's a lot of learnings from across the regions that can inform better advocacy campaigns and litigation strategies and policy making at the US level.
Wonderful, thanks for that. Yeah, both in terms of movement building and in terms of how to deal with the need for abortions in this new context. Charles, let's hear from you about implications of the Dobbs decision. Why is the US such an outlier?
Well, I will add to what Lucia was saying rather than repeat what she has said, and just highlight that there is also a decolonial dimension to abortion, that African countries inherited a legacy of laws that were made without their consent. So abortion laws would be a typical example. So it is perhaps understandable that a region that is seeking to assert itself in every way, in every democratic way, including assert itself in gender equality, would easily be able to understand the oppressive effect of colonially spawned laws. such as abortion laws. Whereas if you look at the Dobbs decision, in particular, the majority, they do really not question the inheritance. They seem to take pride in the historical legacy of abortion laws in the United States, as if to say, we need continuity. We need to continue what we inherited from the United Kingdom. So that could be a very important difference in thinking about regional laws, where the United States celebrates its heritage in terms of laws adopted from the United Kingdom. In essence, the African countries are moving away from that legacy.
Thanks so much for putting that perspective, a new perspective for me of thinking about it in terms of our colonial heritage here in the United States. Sylvia, your thoughts?
Sure. I wanna divide this within the United States and its relation to international human rights law, and then the potential implications that these could have in Latin America and the wave that it's going on, the trend that is going on right now in Latin America with respect to abortion. So with respect to the United States, I agree with what Charles and Lucia said. I just wanted to be clear that the problem of Dobbs is not the decision itself, is the discretion that it gave to states without any type of limitation and any type of legal limitation under international human rights law or international obligations, not only limiting the protection of the Constitution, but also giving no effect at all or no consideration at all to the international legal obligations of the United States. And the problem, what we can see now as a clear tension between international human rights law and the context in the United States are the laws that have been triggered after the Dobbs decisions. Right now, we have bans, almost total bans in a huge number of states, with a number of implications. The obvious tension with the provisions of the American Declaration, and also not only the American Declaration, but treaties to which the United States is a party, the Convention Against Torture, the ICCPR, the Convention on the Elimination of Racial Discrimination. Those are actual treaties that pose international obligations to the United States. There are clear tensions between the provisions of the American declarations and those UN treaties when states decide to prohibit or to ban abortion in cases of rape, or in cases of fetal or lack of viability, or in cases in which the exception is only a risk to the life of the pregnant person and not a risk to the health of the pregnant person. In those circumstances, there is a clear tension between international human rights obligations of the United States and the bans that have been triggered after the Dobbs decision. But there are other dimensions of those tensions with international human rights standards that come to other implications of those bans, not only the lack of access to abortion itself in those circumstances, but also the invitation that it creates, for example, in terms of violation of privacy and secrecy in the context of healthcare. Most of these bans have such ambiguous terms that are almost an invitation to violate privacy in the context of healthcare in general. So to understand whether there is a situation of potential criminalization of an abortion. And that creates a chilling effect on doctors that in terms of providing treatment for miscarriages or, for example, ectopic pregnancies. There are such broad definitions in some of the bans in the United States right now that we've seen doctors reporting a fear of providing healthcare even in an ectopic pregnancy or even in a natural or involuntary miscarriage. And that's very problematic. It's not only affecting the women who want to access to an abortion, but it's also affecting women with other reproductive needs, reproductive healthcare needs. And of course, the other tension that with respect to the most vulnerable women in the United States. That's something that, unfortunately, disparate impact claims in the United States are not protected by the Constitution, are only protected by statutory provisions, but international human rights law, as we know, substantive equality and disparate impact is a key component of equality and non-discrimination. And I just wanted to emphasize what Charles mentioned about decolonization, and this is something that I have been trying to push forward, this narrative that in Latin America, this new trend of decriminalizing abortion, we have some very similar provisions in terms of abortion in Latin America, and when you see objectively all the legal framework that is now taking place in the United States after Dobbs, they are very similar objectively, but the trends are going opposite ways. And in Latin America, the trend is going in an opposite way because of there are some legal enablers for that. And some of the legal enablers for that is that abortion in Latin America, the constitutional protection, the constitutional basis for abortion in Latin America is stronger, is more robust than in the United States. It's not only a matter of privacy, it is a matter of life, health, equality, and non-discrimination, autonomy, because we have a broader range of rights protected in our constitutions, and the protections to abortion have a stronger constitutional basis because of that. And the other is the difference regarding the openness of Latin American countries to international human rights law, to take seriously international human rights law. That has enabled advocates and the social mobilization to include international human rights arguments that have a chance to be taken seriously in Latin America by courts, by legislators, by regulators, which is not the case in the United States. Yeah, that's it.
Thank you. That was full of so many different dimensions and impact of the decision, and really looking at the use of international human rights law that isn't quite the situation here currently in the US. So Melissa, let's turn to you, and I'm going to encourage also our attendees to put questions in the Q&A. I think we'll have a few minutes maybe to answer them at the end. But Melissa, please give us your thoughts on the implications of Dobbs.
Thank you, Patty. Well, I don't know if there's a whole lot I can add because I think my co-panelists have made many really excellent and relevant points from a range of perspectives. But one big concern, the immediate concern that the mandate not only when we heard about the decision that Friday, but really when the Supreme Court appointments happened a couple of years ago. Amy Coney Barrett, I think, was the last among the most conservative to be appointed. Of course, even prior to that, during COVID, we saw state governors issue executive orders, basically effectively limiting access to abortion or denying access to abortion, saying it wasn't essential healthcare. Even prior to that, during our country visit, we did flag, in spite of Roe, of course, there's been the global gag rule, which has wreaked havoc in many other parts of the world. So there's always been a double standard. So my point is that this is something that was in the making for a very long time. So when it actually happened, and after the memo was leaked, the draft was leaked, our immediate concern was, is this actually going to happen? And then once it did, it just really felt like the worst. No doubt a huge setback to gender equality more broadly, because what this conveys, I mean, the take behind this, who are the drivers of this particular outcome? It really is the conservative, extremely religious right-wing forces who are not limited to the United States, who operate globally, but who are significantly resourced from, by actors and entities within the United States. So it really is, we felt that, we feel that, continue to feel that this is a huge setback. It is a reflection of the growth and the power and influence of the religious right and the conservatives. We have also seen this in the Human Rights Council, for example, which is where we are particularly active and we engage with member states. Their voices have grown in number and their voices are more organized. They're very well resourced and they're becoming, I think, more direct in their attacks as well. And it doesn't stop with abortion, right? Gender equality encompasses a whole range of issues. So there are all these concerns that we have also about what does it mean for human rights? What does it mean for norms and standards that have already been established? There's a lot of misinformation, targeted misinformation, so effectively disinformation that is also being undertaking to undo standards that people have fought hard for over many decades and have achieved. So there are all those concerns. But that being said, I think what we're also seeing is that there is a very high level of organizing also happening, because many are looking at the United States and previously they would be inspired, but now they're looking and saying, we don't want to go in that direction. We are not going to make the same mistakes. So we are going to do certain things now to make sure that we can protect the rights that we have. So even in the last several months, even a couple of years, constitutional courts in countries like South Korea, even Thailand, the Supreme Court of India, recently, and then in countries where abortion law reform has been happening incrementally, whereby maybe there was legal reform, but it was followed by a court decision, but then there was comprehensive legislation. Legal and policy infrastructures are being built, and I think more people are recognizing the need for that kind of thinking rather than having the right just stand on one piece of legislation alone or one court decision alone. So there are lessons that are also being drawn from the United States. And I think there's more feminist organizing that's happening now, and organizing across different movements. It's not just, a small group of reproductive rights or abortion rights advocates who are operating alone anymore, but they are working, they're starting to engage with women and other individuals who are active in other movements like labor movements, and other types of movements and areas of expertise as well. So there are, negative, but also positive outcomes, I think, of the Dobbs decision.
Thanks so much, Melissa. I'm seeing this theme of organizing across movements come up in multiple places, and appreciate both Lucia and Melissa raising this up. I have a couple questions I'm going to combine. We have about 5 minutes. I'm just going to put it out for whichever of the panelists would like to answer. Are colleagues already seeing a direct impact of Dobbs in other countries, looking for examples? And are there other SRH issues beyond abortion that are threatened by restrictions as a result of the Dobbs decision? I'll turn it over to whomever wants to answer.
Maybe I can start with the implications. I just want to provide 2 examples, but are mainly distortions of the Dobbs standard. I've seen at least 2, one in Argentina and one in Brazil. In Argentina, in particular, as you know, abortion was decriminalized up to week 14 at the end of 2020, 1920, I think. And the conservative movement has been challenging the law judicially, challenging the constitutionality of the law by means of many judicial actions. And in that context, some judges have referred to the Dobbs decisions, recalling that the Argentinian judiciary has had a tradition of being influenced by the United States Supreme Court. And he tried to present the argument that based on Dobbs, then the legalization of abortion was unconstitutional, which is a mistaken understanding of Dobbs, because the Supreme Court never said it was unconstitutional. But they are trying to have to be very vigilant of this type of distortions of what really Dobbs means. Even if you want to use it, even if you're a conservative judge and you want to use it, you're using it wrong. And that's something that we've seen in Argentina. And also also in Brazil, in the context more, as we know, Bolsonaro, current president, he is extremely conservative with these issues. And in the context of the government, he's been trying to change the protocols for access to abortion in context of rape. And in that context, some officials working with the Ministry of Health have been using Dobbs also in distorting the actual meaning of Dobbs. So that's something that I've seen. And with respect to the second question, I just want to recall that the implications we are already seeing the implications not only in the context of healthcare beyond abortion in terms of other reproductive needs, but also in terms of criminalization. Now the criminalization is being more consistent and more sophisticated, even using, for example, manslaughter when a woman has been using marijuana during pregnancy, and then this ends in a miscarriage. Now we've seen cases of sophistication of criminalization, which is also problematic, and we see that as a consequence of the Dobbs decision.
Yes, I can just add and say that I think in those countries where reform has been ambivalent, and Kenya would be a very good example, where the progressive inscription of abortion in the Constitution is also one that comes with the recognition that life begins at conception rather. I think in those countries, it will embolden opponents of abortion just to drag their feet and not implement the law. We have not seen any concrete evidence as yet. This is really just speculating.
Thank you. Thank you for that example as well. Unfortunately, our hour is just about done. And I really want to thank the panelists for contributing your time. You really are the experts in the field. It's such an honor to have you here with us. You'll see in the chat that this video and also previous videos are available on acil.org. And the Dobbs decision doesn't leave us with a lot of nice things to talk about, but I do appreciate it's been such a pleasure to be with you all and really help us all understand the way forward and really where we're at. This conversation could go on for the rest of the day, but unfortunately we have to stop here. And I would just want to end by thanking you all so much. This was really a tremendous event. Thanks to all of your presence and your contributions. I appreciate it.